right, today we've got a story that honestly has it all. We're talking high fashion, a huge legal battle over a single color, and, believe it or not, a surprise cameo from AI in a courtroom. So yeah, let's unpack this fascinating trademark case.
Okay, so it all kicks off with this shoe, the Christian Louboutin. And it's not just a shoe, right? For a lot of people, it's a statement, a symbol of luxury. And the thing that makes it so famous, so instantly recognizable, is that little flash of red on the bottom, the iconic red sole.
And here's where the trouble starts. At the very heart of this case is this comparison. You've got a shoe from Christian Louboutin right next to a design from an Indian company called Shutiq. You can see the similarities, and you can see why Louboutin saw this and decided to file a lawsuit.
So you're probably looking at that and thinking, case closed, right? Looks like a copy. But no, this is where we start to peel back the layers of the onion, because the legal reality is way more complicated than it looks on the surface.
Okay, so the case heads to the Delhi High Court. Louboutin's argument is pretty simple. They said the shoe boutique, or Shutiq, was imitating its signature designs. And at first, the court totally agreed. They took one look, compared the shoes, and declared the defendant's products were knockoffs. But hold on. This is where things get really interesting. Because the whole thing boils down to a massive, fundamental question. Can you actually, legally own a color? So if you want to trademark a color, you have to jump through this huge legal hoop called acquired distinctiveness. It basically means you have to prove that when people see that color in that specific context, they don't just see a color anymore. They see your brand. It has to become an instant signpost that points directly to you and only you.
And this is so key to understanding this. Louboutin doesn't own the color red, period. No way. Their trademark is super specific. It's what's called a position mark. They only own the color red when it's applied to the outsole of a woman's high-heeled shoe. That's it.
Okay, so keep that very specific trademark in your head. Now look at one of the shoes that was actually part of this lawsuit. It's a men's loafer. Sure, it's got a red sole, but it's a totally different beast from the high heel in the official registration.
And this leads to the million-dollar question, right? A question the court in this case didn't really dig into. Can you take this super narrow trademark for one very specific type of shoe and just stretch it to cover all these other things? Men's loafers, sneakers, boots, you name it?
And you know, this whole battle over the color red isn't just happening in India. Oh no, Louboutin has been fighting the same fight in courtrooms all across the globe. And, spoiler alert, the results are all over the place.
Just look at the scorecard here. In the US, they kind of won, but with a big if attached. In France and Japan, total losses. The courts there said the color just wasn't distinctive enough. Brazil, on the other hand, was a win. The point is, this is not a settled issue. There's no global consensus here.
But wait, there's more. The red sole wasn't the only thing on the table. Louboutin also went after them for copying their spiked shoe style. And here's the kicker. That style isn't even a registered trademark. So now we're in a whole different legal territory.
Yeah, when you don't have a registered trademark, you have to rely on this other legal concept called passing off. It's a fancy way of saying you're accusing someone of making their product look so much like yours that they're tricking people into thinking it is yours, and that's causing damage.
And to win a passing off case, you have to nail what's known as the classic trinity. It's a three-part test. First, you have to prove you have goodwill, basically a famous reputation. Second, that the other guy's product is confusing people. And third, that this confusion is actually hurting your business.
So the big question is, did Louboutin actually prove all that? Well, the evidence was shaky, to say the least. I mean, spikes aren't new. Think punk rock in the 70s. Plenty of other big brands sell spiked shoes in India. And when you look at Louboutin's own sales numbers, it works out to a pretty tiny number of shoes sold across the entire country for all their styles, not just the spiked ones.
Okay, so with the evidence for the spikes looking pretty thin, Louboutin's legal team tried something new, something very 21st century. They decided to bring an AI into the legal battle.
I am not kidding. To prove their spiked shoes were famous, the lawyers literally submitted a screenshot from ChatGPT. Their whole argument was, look, even the AI knows that when people think of spiked shoes, they think of us.
The judge, though, wasn't so easily impressed. She was skeptical and decided to run her own little experiment. The lawyer's very specific leading question got the answer they wanted. But when the judge asked a more neutral question like, who makes spiked shoes? Boom,
ChatGPT listed a bunch of brands. It was a perfect example of how you can totally influence an AI's answer just by how you phrase the question.
So in the end, the judge threw that piece of evidence right out. She basically said that AI, as it stands, just isn't reliable enough for the courtroom, and that it can't replace the actual human judgment needed to decide a case.
But here's an interesting counterpoint. Maybe the court dismissed this new tool a little too fast. Sure, one screenshot is junk evidence, but think about what a large language model is. It's a reflection of a huge chunk of public conversation on the internet. If you use it rigorously, ask hundreds of different questions, analyze the patterns, it could actually be a really powerful tool for gauging what the public thinks, maybe even more objective than just looking at ad budgets.
Okay, let's pull back and look at the big picture. Why should we care about this case? I mean, it's about expensive shoes and a chatbot, right? Well, it's because this case bumps up against some really huge fundamental questions in intellectual property law. And this is probably the most critical detail of the whole story. The defendant, the small Indian company, they didn't really put up a fight. They just folded pretty quickly and agreed to stop selling the shoes. And what that means is that all of Louboutin's big legal claims were never actually challenged or tested in court. And that's a problem. Because according to legal experts, this is exactly when a court needs to be most careful. When you have a David versus Goliath situation and David can't afford to fight, it's the judge's job to really scrutinize Goliath's claims and make sure they're solid. And the big concern here is that maybe in this case, that didn't quite happen.
Which brings us to the final big question at the heart of all this. You know, all creative work, especially in fashion, builds on what's come before. So this case really makes you wonder, in our modern world of global brands and fast fashion, where do we draw the line between inspiration and illegal imitation? And maybe more importantly, who gets to be the one to draw that line?